Welcome to Estate Planning Beyond the Binder.
Hello and welcome back to Estate Planning Beyond the Binder with Brian Chu. Brian is the managing partner at OC Wills and Trusts and has over 25 years of experience helping families in Orange County protect what matters most through thoughtful estate planning. I'm Kevin Rosenquist, and today we're focusing on planning for incapacity. If you become unable to make decisions because of illness or injury, who will step in to manage your finances or your medical care? Without a plan, the courts may decide that for you. Brian, welcome back.
Thank you, Kevin. Thank you for having me on again.
Yeah, so this is definitely something that I think people don't necessarily consider. I think with estate planning or with wills and whatnot, is everyone thinks about when they die, but what about if you're legally incapacitated? So let's start with the basic definition. What does it mean to be legally incapacitated, and what are some common circumstances where this might occur?
Here are the basics. Anybody under the age of 18 is technically legally incapacitated.
Okay.
But that's not the issue that we're really dealing with. It's basically
some more than others.
Yeah, and I had a 15 and 17-year-old, and there's a good thing. I'm not making now. The other is, you're incapacitated because you can no longer make financial and or medical decisions for yourself. You're no longer able to, you don't have sufficient mental capacity where you can make decisions, where you're allowed to effectively do things like sign legal documents, as an example. Pay, access bank accounts, pay bills, make medical decisions for yourself. If a doctor says, your attending physician says you're no longer able to make decisions for yourself, well, who can then? And that's the issue. And that's, and when people say, who needs estate planning, I always tell people, anybody that's a legal adult needs some sort of an estate plan. And the estate plan isn't necessarily about the money, who gets any money, because, a lot of us, a lot of people, especially when they're young, they don't have a lot of money necessarily.
Right.
But it's really the issue is, well, if you were in a car accident, and again, that's the most dangerous thing we do every day is for most of us get in a car and something happened to us, and we get a car accident and we're unconscious, who's accessing bank accounts, who's making medical decisions for us? Because if you have no documents, nobody's in charge. And at that point, you're not able to give anybody permission to be in charge because, well, you're incapacitated.
Right.
And so that's why, that's the very basics for anybody. In fact, that's what a lot of my clients, they have, college age kids, people, kids have just turned 18. And I encourage those clients, again, the kids don't need an estate plan in the sense of who gets any assets necessarily. They do need a plan to make sure that their parents, example, could make decisions for them. Most importantly, medical decisions.
Right.
I always tell people, that's the single most important because of HIPAA laws. Which basically HIPAA privacy law, medical privacy laws basically say when somebody's, hospitals and insurance companies and doctors cannot give your medical information to anybody else without express written permission. Okay. And so that means if you're unconscious at the hospital, well, you can't give that permission. And so the question is, does anybody possess a document that says the hospital is allowed to talk to them? And that's problematic, especially for my clients. Again, their kids may be off in college, especially if, the hospital might tell them something in person, but they definitely will not tell them anything over the phone. So if your children, are, across the country or traveling or whatever, away from home, away from the potential decision makers, how would they have any ability to get information if you're in the hospital? Right. And unconscious, because again, the hospital cannot release that information to anybody else without written permission, and you're not in a position to give it. And so that's, when we start talking about incapacity, that's their number one issue is, who has access to your medical information. Then obviously, God forbid, medical decisions need to be made. Who has authority to make those decisions? But they got to have access to the information first.
Yeah, I feel like a lot of people probably just assume if you're married, you just assume it's your spouse, or you might assume it's your adult child, or you assume that it's your parents if you're, younger or unmarried. Is that generally a safe assumption or not necessarily?
It depends. It's not automatic. Legally, it's not automatic. Okay. Now, with that being said, I have a number of ER doctors who are clients of mine, and I've spoken to them. How does that work? At the end of the day, they're making, if there's, if they need to talk to somebody about the situation, they're making a judgment call.
Right.
Okay.
Yeah.
They're saying, I think this is the right person, the parent, the spouse, the sibling, I think this is the right person to talk to, even without documents. But but I don't want to count on that, especially since I asked the doctor, well, is that the proper protocol? Is that what the hospital is saying you can do? And they're saying no. Of course, the hospital's saying no. You're not supposed to do that. The hospital is trying to they're trying to cover themselves.
Yeah, they're trying to protect themselves.
Liability.
Mm-hmm.
The doctors, they're making more of a compassionate call, I think, there. Right. But I don't want to count on that. And again, that's in person. Again, doing this remotely without any proper documents is really difficult because they cannot, they have no way of ascertaining who you are at that point.
That's a good point. It's one thing to be sitting in the waiting room of a hospital or something like that, and the doctor comes out. It's another thing to be 1,000 miles away, kids in college, or you live somewhere else. Yeah, you're right. It makes a lot of sense.
And that's the big issue. That's why, again, anybody over 18 should have a power of attorney health directive signed that gives somebody, their parents or sibling or somebody else they trust, the authority, A, to get medical information about you, and then B, make decisions. Because in order to be declared incapacitated, the doctor has to be able to tell you somebody's incapacitated. If they don't have permission to give you that information, well, they can't tell you. They can't give you a letter saying you're incapacitated.
Right. So can you talk about what a conservatorship is and the difference between that and a power of attorney?
So they're very different. So a power of attorney is something I sign that says if I become incapacitated, here's why I want to be able to take over. Okay, who can sign on my behalf, and here are the backup people. Okay, and that's something that's a planning I can do in advance so that I get to choose who's in charge when I can't be. Conservatorship is different. Conservatorship is, and this is typically for an adult. It's for an adult. I feel it could be my sibling. My sibling is not making very wise decisions. There's something, and there's something wrong. Again, it's something beyond, they're just unwise. They can't make the proper decisions for themselves. And I can go to court and get what's called a conservatorship. There's two types of conservatorship: conservatorship of the estate and conservatorship of the person. Okay, a conservatorship of an estate is, I think Britney Spears recently had that.
Right.
Her father was her conservator. He went to court to say, I need to take over her because she's not in the right frame of mind to manage her finances. I want to be the person to manage it. And he goes to court. And obviously, in this case, the judge approved him to be the conservator of his daughter, Britney, in this case. And obviously, that's an involuntary conservatorship in that case, in which case you have to prove to the court why this person's not capable of managing their own affairs. Obviously, there's other types, and then the conservatorship of the person, which is medical decisions. Okay, the person's not making the right medical decisions for themselves. They need to be in they need to go to the hospital or something like that. They're not going, and now we need to compel them to go. And that's where you can get a conservatorship of the person, where you now can make medical decisions for somebody else when they cannot. Now, obviously, those are kind of the people think about conservatorship as involuntary, where the person doesn't want the conservatorship. They might fight it. Obviously, there's other situations where it is, unfortunately, we have somebody who's disabled, a child who now becomes an adult, because while they're a child, you have control. You're in control of them, their estate and their person. But once they're an adult, you may now need to be conservator of their person so that you can make medical decisions for them, and conservator of the estate to the extent there's money to be managed or legal issues that decisions need to be made, that you can make the decisions on behalf of that person. And that's typically not necessarily voluntary, but that's that person, they have to have it.
And so similarly, is power of attorney and durable power of attorney, are those kind of different in the same ways as far as finance versus medical?
No. So you have two different types of directives. You have power of attorney, which is financial and legal issues, and then you have healthcare directive.
Healthcare directive.
And that's what we call it in California. It may be called something slightly different in other states, but they are two separate documents. And again, one's about you, which is the healthcare related, and then one's about anything you can sign for that's not related to your medical decisions. And then the difference between durable power of attorney and regular power of attorney. And here's the funny thing, we do almost 100% durable power of attorneys because I'm not sure what the purpose of having. Well, I mean, there are some purposes, limited purpose. The reality of a non-durable power of attorney essentially is that doesn't last through incapacity. So in other words, if you become incapacitated, the power of attorney is no good. So that's why you want a durable power of attorney, because you want that. The whole point of having the durable power of attorney is you want it to last through incapacity.
You said there are some cases where having a regular power of attorney is good. What would those be?
I think usually the most common is escrow companies use them when somebody is selling up. There's there's two owners on a property, and one owner says, I'm going to let them, them sign on my behalf, and so they'll do a limited power of attorney. That's where I see that. I'm not sure what I mean, I think it's just more specific, maybe in short-term situations, where I'm going to allow, someone, I'm going to sign a power of attorney, allowing somebody else to sign on my behalf for either a express purpose or limited period of time. But it's mostly not because I'm incapacitated, it's because it's not convenient for me to sign or something like that.
Mm-hmm. Let's clarify some other terms as well. How does a healthcare directive differ from a living will, and how do these guide medical decisions?
The living will is typically part of the healthcare directive.
Oh,
okay.
Gotcha.
The health directive is the overall document that says who can make decisions about me when I can't. Okay, and who's in charge and when are they in charge, which is typically immediately. But and then within the healthcare record is the living will. The living will is typically regarding end of life decisions. Primarily, the primary situations is that person's unconscious, being kept alive artificially, and the doctor says they can do nothing else for them. Okay, then they return to your agent and they say, "What do you want us to do?" Within the living will, it will dictate what your decision is, which is either I want my life, don't prolong my life. In other words, if you agree with the doctor after doing your due diligence, get a second opinion, whatever you want to do, consult with whoever you want to consult with. You're in agreement with the doctor, nothing was done. I'm saying turn off the machines. Okay. Mm-hmm. And the other is prolong, which is I really don't care what you as my agent or the doctor thinks at this point. Keep me alive in the machines for as long as the machines can keep me alive, even though the insurance is going to run out at that point, or they'll stop paying at that point. But I just want to be kept alive in the machines as long as the machines can keep me going. So that's the living will.
Okay. Yeah, it's interesting because I feel like this is the kind of thing I think you might have mentioned at the top of the show, that a lot of times people don't think about this as part of an estate plan. They think about it as far as, who's going to get money. But this is a really big decision. And I think as we've talked about in the past, you're helping people to not have to make that decision on, on their own. You telling them what to do if you're in that situation, because I mean, it's like a classic, like kind of a movie thing, should they pull the plug or should they not? Right. But you kind of take that horrible decision off of their plate by doing this.
Yeah, for the most part, you do. I mean, you're leaving a little bit of gray area for them to make, maybe a different decision than what they, disagree with the doctor. Okay, I guess they'll keep you alive, but you've at least relieved them of the burden of saying, if I were in that situation, and that's how I usually, pose it to my clients. If you were in that position where you didn't think anything else to be done, what would you want done? Again, you won't be in that position because you wouldn't be, you can't make a decision at that point. But what would you want that done? And so when people think about that, that's where they tend to, like I said, even if they're thinking about, what if there's a miracle or something like that, that's where they think, well, I really want to make it easier on my family to let me go at that point without the guilt of having done so.
Right. Yeah, exactly. Without having to remember that you made the decision to do that. If you're following the person,
you're executing someone else's decision. Yeah. That person's decision.
Okay. And so now you still do choose like a someone to make these decisions, a specific person, right?
Correct. Yeah. I mean, and again, that's why it's part of estate planning is, I always tell people estate planning is who's in charge when you can't be of yourself, or your money, or if you have minor children like myself, your kids. So again, who's in charge of you? And you want to have I always tell people that's the single most important decision you're going to be. Well, I mean, not after your kids, anything about your kids. The single most important decision you're going to make is about you. Who's making decisions for you?
Yeah.
Who do you trust to make those type of end of life and otherwise decisions when you can't? And so that's why we encourage everybody over 18 to get some sort of estate plan in place because you want to have a say. And one thing to clear up on the healthcare directive, because a lot of people ask me the first thing, is this a DNR, do not resuscitate order?
Oh, yeah.
I always tell people this is not the living. When you say I don't want my life prolonged, this is not a do not resuscitate order. Okay, a do not resuscitate order is a order signed by a doctor that you requested. Okay, which again, most people were not requesting those things ahead of time because we want to be revived.
Yeah, please.
And even if you had a do not resuscitate, even if you had a do not, even if you had a do not resuscitate order somehow, and for some reason, unless you happen to be carrying that around, and I'm not even sure then, even if you were carrying it around, if you had a heart attack, I'm pretty sure whoever's around is going to call 911. When those paramedics showed up, the paramedics are not reading paperwork. They're not going to say, "Oh, this is a
they're
DNR."
doing their job and they're doing it quickly.
They're just going to revive you every time. I always tell people the DNR, the purpose of it is when you're stable, okay. At that point, there is the potential for your family, or if you're going into a situation where you don't want them. If your heart fails at that point, you don't want them resuscitating you. They'll, and with the agreement of the doctor will sign the do not resuscitate order and put it on the door. That's about the only circumstance where a DNR will work, because any other circumstance, nobody's going to take the chance that there's some sort of document that says don't resuscitate. They're going to resuscitate you every single time unless it's on the door and it's explicit. Yeah,
because like to your point, I mean, it's usually an emergency situation. So, if paramedics are showing up, they're probably not like, does anybody have a DNR for this guy?
Yeah,
DNR?
No, they're going to do their thing.
They're going to do their job, and they're going to make sure this person
figure it out later.
Yeah. Yeah. Is this something that are these we've talked in the past about, reviewing, updating documents and plans and whatnot. I mean, I suppose this is something that should be updated or at least reviewed pretty often, just in case things change, huh?
I mean, I would say that most of the times it's because the people you have currently in charge has changed. Your relationship with those people or somebody else has gotten better or it's gotten worse. My case, my kids are still teenagers. So, within the next decade or so, I hope I will trust my kids enough that I'll put them onto my, update my healthcare directive to put them on as, backup agents to my spouse instead of my siblings and such. So, the medical, the decisions that are on there, are, unless philosophically things change for me, are probably not going to change. I guess there could be legal changes, but the document hasn't changed in quite some time. And again, I don't think there's any. Well, who knows politically what's going on now? But
that's a whole other conversation.
That's a different conversation. Again, it's usually on the healthcare side. It's who do you want to make decisions, and B, who do you want to have access to that information? Because it is as part of our planning. Not only do we create a list of people who can make decisions, we also, in addition to those people, we also potentially have a list of people that can get medical information, would have no rights to make decisions.
Right.
Could be parents. Could be, siblings that are on the list. You don't want them necessarily precluded from, that classic hospital scene, people in the waiting room. In theory, if the doctor comes out and discloses information, technically, if you're not on the HIPAA list, you're not supposed to, you shouldn't be in the room. But that's maybe more in the movies than it is in practice.
I was going to say, I don't think script writers are aware of this, perhaps, or it just it wouldn't make for good drama.
That's why I say, who else can be in the room?
Mm-hmm. All right, good stuff. Well, thanks for listening to today's episode of Estate Planning Beyond the Binder. Planning for incapacity is not something anyone likes to think about, but it's one of the most important ways to protect your family from stress, expense, and of course, uncertainty. To learn more or schedule a consultation, visit ocwillsandtrusts.com or call Brian and his team today. Don't forget to subscribe to our channel. Keep up with everything that we're doing. We got lots of great stuff coming your way. Brian, always love chatting with you. Thanks so much for your time.
All right. Thank you, Kevin.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.